and welcome to our New South Wales Small Business Month webinar series on HR essentials for regionally based small to medium businesses and not-for-profit organisations. My name's Bronwyn Pearson. I'm the CEO of Pinnacle People Solutions. I have over 25 years experience providing the full range of HR advice, support, solutions, services, etc. to regional employers of all sizes, and it's been a privilege to enhance regional communities by supporting local businesses across the state. So at 5:30 each Wednesday afternoon during the month of October, and this is the second in our series, we will be refreshing ourselves on the HR basics. Last week we looked at contracts and position descriptions. This week our focus is on record keeping obligations, and the following topics that we'll still be doing in October, the final two, are paying staff correctly and policies and procedures. All of these videos will remain on our Facebook page and website, along with accompanying fact sheets. So you can come back and review them anytime, and make sure to let your colleagues, families and friends who are involved in small business know, so that they can get access to them also. So good evening to those who are joining us this evening. We are absolutely delighted to have you with us, and we'd invite you to ask any questions that you might have as we go along this evening. I'll do my best to answer those, and would be delighted to have a conversation with any of you that may have specific questions about your business. And thank you to my wonderful team who are going to be putting up those contact details for you in the chat screen this evening, so that you can get access to that information as you need it. Terrific. Thank you guys very, very much. So tonight we are looking at the incredibly sexy topic of record keeping obligations. Now, I know this is, for most people, is going to seem dry as a bone, but what I need you to be aware of is that boy, can this bring businesses unstuck. So really brave of you to be joining us this evening. Importantly for you to be joining us this evening, and hang on to your hats. Let's get stuck in. So often the thought of lawfully required and best practice record keeping makes small business owners feel stressed and overwhelmed. It's certainly one of those areas that it's important that we talk about, particularly when we're looking at business basics for small business. Tonight, we're going to talk about what your obligations actually are, what's best practice, and how we can help you set up systems and procedures to make it easy for ourselves as small business owners as possible, whilst complying with our privacy obligations as well. So let's look at the first fundamental question. What is lawfully required under the Fair Work Act? So under the Fair Work Act and regulations, bearing in mind that the vast majority of us small business owners and people employed by small business are employed under the federal system of employment, which is underpinned by the Fair Work Act and regulations, and the National Employment Standards, which are the minimum terms and conditions of employment that apply to everybody employed under the federal system. So under the Fair Work Act and regulations, employers have to keep a record of information for each employee that they engage. Now that includes records regarding pay, leave, hours of work, expenses reimbursed, workers' compensation insurance, and super contributions for a minimum of 7 years. Tax records include tax that's been paid, superannuation calculations and payments, and information about how you met your choice of super fund obligations. Those things, tax records, super records, calculations, etc., need to be kept for 5 years. So how do you keep that information? There's a whole range of different ways in which you would keep and retain that information. Pay slips, timesheets, and onboarding documentation such as new employee forms are some of the ways that you would be keeping and recording that information. All of those documents, and I'm going to go through them in detail, so don't be panicking at this point about what you need to do. We're going to go through it step by step. So all of these documents must be legible, they must be in English, and they must be readily accessible if Fair Work comes knocking. And believe me, they come knocking, and they come knocking regularly, and in particular in regional areas. So they are out and about, so it's important to have your ducks in a row in the event that you need to show someone your ducks. So they must be kept also those records must be kept private and confidential. The only people who should be able to access them are the employer, so you as the business owner, payroll staff, the employees themselves if they request that, and other authorised individuals such as an accountant or a HR business partner. Okay, so let's have a look at some of the HR records, the employee record fundamentals. You need to keep time and wages records for 7 years. Those time and wages records have to be readily accessible to a Fair Work inspector if you're asked to supply them. They must be legible, they must be in English, as I mentioned. Time and wages records cannot be changed unless it's changed due to an error that you discover, and they can't be false or misleading, whether deliberately or innocently. Here's a best practice tip. You should keep records of hours worked for all employees, including piece workers, shift workers, any staff, including those on salaries. Now, we've had some recent decisions in the last 12 months that have come down from the Federal Court and through the Fair Work Commission in respect of particularly salaried employees and the need for employers to be keeping time and attendance records for everyone. So the idea that you put someone on a reasonable size salary and then you don't have to worry about keeping their time and attendance records is long gone. So if you've got any questions about this, don't hesitate to get in touch with us. We'd be very, very happy to give you further information that you might need that is relevant to your business. So you should adopt best practice record keeping because it does make it easier to keep track of your employee details, identifying payroll mistakes, and keeping your business running efficiently. It also helps avoid fines for doing the wrong thing. And you might have been keeping up in the media for the last 12 to 18 months of all of those very large employers, public and private, who have been found to have mispaid, underpaid staff in a whole range of different ways and not kept appropriate records, etc. It's not just happening to small business. If big businesses can get it wrong, so can small businesses. The fines and the consequences can be just as significant, if not more so, for a small business. We can help you with templates for weekly time and wages records, employment records, that's both yours and employee details, rosters, as well as timesheets. So you need to keep a certain type and amount of information for each employee. If you have somebody who's paid an annual wage under an award, you are required to keep extra records for those staff, and we can give you the details of what that looks like as well. In general terms, there is a list of records that you must keep, and that is in terms of general information. You need to keep your employer and the employee's name, your ABN, the employee's commencement date, whether they are full-time, part-time or casual, whether their employment is permanent or temporary. In terms of their pay, you need to keep records as to their pay rate, their gross and net amounts that are paid, any deductions that are made from the gross amount, details of any incentive-based payments, bonuses, loadings, penalty rates or other monetary allowance or separate identified entitlement that you need to pay that staff member. You need to keep hours of work records, and that would include any penalty rates or loadings that you pay to staff for overtime, including the number of overtime hours worked by an employee during any particular day, and when the employee started and finished the overtime hours. You need to keep records as to the hours an employee works, if they're a casual or a regular part-time worker, who is paid based on the time that they work, and a copy of the written agreement if you and the employee have agreed to an averaging of their work hours. In terms of leave, you need to keep records as to any leave taken, how much leave the employee has at any particular point in time, and if an employee is able to cash out annual leave, you must keep a copy of the a written agreement to cash out the amount of leave, a record of how much was paid, the amount of leave that was cashed out, and when the payment was actually made. If your staff member is under an award, you need to agree for an employee to take annual leave, and you agree for somebody to take annual leave in advance. you need to keep a copy of that agreement, and the agreement has to say the amount of leave taken and the day that the leave started. In terms of superannuation contributions, you need to keep records as to the amount paid, the relevant pay period, the dates that that money was paid, the name of the superannuation fund, and the reason that you paid into that fund. So a record of the employee's super fund choice and the date that they made that choice. If you pay a defined benefit interest into a defined benefit fund, you don't have to include these contributions in the record, just to be clear. If you have an individual flexibility agreement with any individual employees, if you agree to such an agreement under an award or a registered agreement, then you must include, your records must include both a copy of the written agreement and a copy of any notice or agreement to terminate that flexibility agreement. If you have a staff member who has a guarantee of annual earnings, you need to keep a written record of the guarantee and the date the guarantee was cancelled, where that's applicable. In terms of ending somebody's employment, you need to keep records as to how the employment was terminated. So, for example, was it by agreement? Was somebody summarily dismissed for serious misconduct, for example, or in some other way, specifying, of course, the details of the termination. If notice was provided, you need to keep clearly a record of notice, and notice should be provided, except in the case of summary dismissal. And if so, how much notice? The name of the person also who terminated the staff member's employment should also be part of the record. Importantly, when it comes to the transfer of business, so if you're looking to sell your business or transfer it to somebody else, or indeed you're looking to purchase a business or be transferred the ownership of a business by someone else, where there has been such a transfer of business, the old employer has to give the new employer records of any transferring employee. The new employer also has to ask for employment records from the old employer for any transferring employee who becomes an employee within 3 months of the sale or the transfer of the business. So, who can access records? Employee records are very clearly and importantly private and confidential. So only the employer, payroll staff, the employee, and authorised individuals such as an accountant can access the records, as I've mentioned before. If one of your staff asks to see their records, you must make them available, and this includes after an employee has ceased employment. You can also, Fair Work inspectors, for example, as I mentioned earlier, can also ask for time and wages records to find out what an employee is entitled to and whether they've been paid correctly. So what happens if records aren't kept? If records aren't kept or they're incorrect or incomplete, Fair Work inspectors can give you a fine, which is called an infringement notice. It's unlawful for employers to make or keep employment records that they know to be false or to be misleading. Employers can also be penalised if the Fair Work Ombudsman chooses to take a matter to court. And in some cases, employers who haven't kept records or made records available for inspection may have to prove to a court that they didn't underpay an employee, for example. Okay, so I'm just keeping an eye on the chat screen here to see if I've had any questions to this point in time. So please don't hesitate to pop up and ask any questions that come to you while we're going through this presentation. Of course, our contact details are there if you want to reach out to us separately or after the presentation if you've got any particular questions that might be pertaining to your business specifically. So what else should I be recording? Okay, it is also best practice to keep records of job applications, including resumes and any trade, certification or registration certificates for staff or contractors. It is important to note, however, and again this relates to the Privacy Act provisions, that you cannot retain job applications or CVs, resumes, etc., or any candidate information past the conclusion of a recruitment process without getting the written permission of the candidate. Now, an email is sufficient to do that as in terms of what may be constitute in writing agreement, but you can't keep those records without asking the candidate in writing if you can, and them agreeing. Very importantly, in terms of independent contractors, so that's any organisation or individual who has an organisation who you contract to provide services to your business, so they're not an employee, they're an independent contractor, For any independent contractors, you should have, very importantly, a pre-qualification checklist for each contracting entity, which checks off all of the policies, procedures, qualifications, licenses, certifications, checks, and insurances that those contractors need to have before you engage their services. Now, if you haven't done that before, do it now. Make sure that any and all contracted entities to your business have everything in place that they should have in place, because here's the rub. You will face substantial risk if your contractors don't have the right certifications or insurances. You could in fact be liable. And unfortunately, we've had to help a number of organisations who've ended up being liable, particularly in the workers' compensation space, for the employees of contractors who have not been adequately insured. So they're working on your premises, providing services to you, and they have staff potentially that are also doing that. You want to make sure that they've got all of their ducks in a row, because you could be liable if they don't. Also, when following any procedures that you have about managing complaints, for example, or performance management, any allegations that might be raised against a staff member, it is important for your own protection and your business's protection and risk management to make sure there is, at minimum, file notes in writing on the relevant staff member's file. So let me give you an example of what would be good performance management documentation, or if you had an issue of insufficient performance, or say misconduct on the part of a staff member. So you would potentially, if this was to be dealt with formally, even if you deal with things like this informally in the first instance, you want to keep file notes. Particularly of any verbal warnings that might come out of things. You want to keep records of what you've done before, because if you do get any repeating patterns of behaviour, or you want to have demonstrated that you've actually been through a process previously, it's no good if it's all been verbal. You've got no way, potentially, of proving that you have a documented history of processes that you've followed. So let's say that you've got a performance management issue or a misconduct issue. So you would, if you've got to have a conversation with a staff member about a performance or a conduct issue, you should generally give a notice of meeting letter ahead of having a formal discussion with them about performance or conduct. In that letter, you would invite them to bring a support person with them to the meeting if they chose to. It's important to indicate that that shouldn't be a practicing barrister or solicitor, or indeed a co-worker. I can explain why for individual details if you need that. You want to keep notes of the meeting that you have. You want to provide the staff member with a record of the meeting afterwards, including the purpose of the meeting, the date, the time, who was present, all of those details, as well as what the agreed outcomes were and what the measures of improved performance or resolved conduct need to look like and over what period of time. You might want to complete a performance improvement plan with the staff member if that's appropriate, particularly if it's a performance issue. You want to document any verbal or written warnings, and you want to follow up and evaluate with the staff member how the agreed outcomes are going in terms of what's being met and when, and what was achieved. Particularly, that is incredibly important if those outcomes don't end up being achieved and you ultimately end up in a situation where you might be looking to terminate somebody's employment. Due process is your friend. Documentation is your friend. It's really important, and to keep good, appropriate documentation. It doesn't have to be a war and peace, I promise you, but it does need to be adequate for you to be able to demonstrate that you've followed due process accordingly in the event that somebody challenges you. And let me tell you, that is happening on a far more increasing basis now than it ever has been before. In the case of injuries at work, you want to make sure that you've got appropriate written records of any injuries or near misses in the work environment, including witness statements and exact information about dates and times, as well as any notes of verbal discussions and copies of any appropriate medical information. By law, under work health and safety legislation, you should have an incident register and reporting of incidences, and a process for that everybody in your employee understands. So ideally, an incident reporting and investigation policy and procedures and some checklists for that would be entirely appropriate. And next week we're going to talk, not next week, the week after, our fourth in the series and final in the series is going to be around policy and procedures. So tune in to that with us, and we will talk about that further. So while we're on the topic, as we've just touched on in terms of health and safety, what is lawfully required under the work health and safety legislation? In summation, a lot. There is a list of requirements for what you need to keep in terms of health and safety records that is much longer. It doesn't usually directly relate to individual employees as such, except where you have incidences, for example, that you need to record. But it does require you to document things like a master list of where relevant health and safety documents and policies and procedures are stored, agendas and minutes of health and safety meetings, records relating to checking qualifications of contractors, for example, assessments of appropriateness of your plant and equipment, completed checklists for those sorts of things, etc. So there's a lot there that you need to keep records on in terms of health and safety under the health and safety legislation. I want to give you an example of just one element of health and safety that you would be required to keep records in relation to, and that's, let's have a quick look at a worker induction record. Okay, so you've got a new staff member coming on board. That induction, practical induction to the work environment would involve things like welcoming them to the work environment, introducing them to management and supervisors and co-workers, being clear that they understand work hours, meal breaks, overtime, for example, that they're very clear on their work tasks and their duties and responsibilities as per their job description. You want to make sure they have a good tour of their workplace and that they are very clear about where toilets and amenities are located, where there are first aid kits and the names of first aiders for your business, where the manager's office and location is, notice boards and work health and safety information and signs in the business, for example, exit points and evacuation instructions, location of the nearest work health and safety manual and safe work procedures for any procedures, plant and equipment that they'll be using, explaining what the health and safety management and procedures are for the business, talking about the health and safety consultation mechanism and ways to resolve health and safety issues, record and resolve those issues, taking them through hazard and incident reporting procedures, taking them through workers' comp claims procedures where relevant, and return to work program where that's relevant, talking them through any hazardous substances procedures if they're going to be dealing with hazardous substances as part of their job, taking them through personal protective equipment where they're located and stored and allocating appropriately fitting PPE to them depending on the nature of their job, making sure that they're trained in the evacuation procedure for the business, any manual handling procedures that they might need to be taken through if that is part of their job, and making sure that they have adequate training and competency based on the work health and safety risks that might be in their specific job tasks. So that's a bit of a mouthful, but that is a really fundamental worker induction record that you would want to keep and that work health and safety legislation says you need to keep whenever you have a new staff member that starts. Okay, so I can hear the groans from here. And I imagine that a lot of you are thinking, this seems like a heck of a lot of paperwork. How can I fulfill these obligations lawfully? Good news is that these records don't have to be stored as hard copies, although you can if that's what your business chooses to do. I have to say, fire, flood and other misadventures terrify the life out of me. So we always recommend that our clients set up a secure online filing system that is backed up on a regular basis to manage employment records in particular and also health and safety records, and invest in a good quality scanner is our advice. We use Dropbox, but there are many other products and systems out there that you can use. And even if you do produce and maintain paper records, such as timesheets or forms that are filled out and signed by hand and so on, you can immediately scan them into your system and file them accordingly, and you don't then need to keep the paper original once you've confirmed that the electronic file has been scanned and saved correctly. Saves you a lot of time and room too. If you do keep your pay, leave, timesheet, tax and superannuation records within your accounting or your payroll system, make sure you back it up regularly in case something goes wrong. So you'd want to make sure you've got a good triple backed up system. And the key to any good quality record keeping and filing system is, not surprisingly, consistency. So we want you to be able to be consistent in terms of naming your documents, consistency of where you locate them, and consistency of secure destruction of documents that are no longer required. So one of the common questions that we get asked by clients or potential clients is, what happens if I'm not keeping records accurately or well? What happens if I'm sitting here listening to this thinking, I really don't know that we're doing what we need to be doing? The fundamental problem with that is that you can't prove what you might need to be able to prove at some point. And you may indeed be found to not have done the right thing in terms of due process. You may have done the right thing, but if you can't prove it, then you're in a whole lot of pain, potentially. Even if the end result makes sense. So common sense doesn't necessarily apply in terms of the law, and verbal agreements more often than not do not apply. You need to be clear and to have your expectations with staff and of staff in writing. You could be fined significantly because ignorance is no excuse under the law. The law expects you to know what your employment obligations are and to comply with them. It's as simple as that. And unfortunately, oops, I didn't know, doesn't cut it. So due process and documentation are both your friend. Be clear and keep good records. There are some you must keep, and others you'll be glad that you did. Particularly when you need them, and invariably you're going to at some point. Your business, interestingly, also won't be worth as much as it could be if you want to sell it or transfer it to a family member or another entity. You have to meet lawful transfer of business obligations when it comes to selling or transferring your business, and if you don't have the records, you're not going to be able to make that sale and keep those obligations. Your business may also not get access to tenders and contracts that you might want, particularly with larger contractors or government contracts, for example. Aside from the employment law obligations for record keeping that we've already talked about this evening, larger contractors and government agencies will expect to see a standard of HR and work health and safety infrastructure, record keeping and risk management in your business that you may not currently have. So if you do aspire to be eligible for tender and contracting arrangements with large contracting companies and the government, you want to get those ducks in a row because they're definitely going to require them. And there's a lot of infrastructure projects happening at state and federal government level in New South Wales in the coming 12 to 18 months that you might want to have a piece of. And if you do, those entities are going to want to see that you have those ducks in a row. So let us know if we can help you with that. So let's just be clear about privacy. I know we touched on it earlier, but you do have obligations under the Privacy Act as well as employment law obligations. You do have requirements for privacy of information that you hold on people, and you need to make sure that only people who are authorised in your business should be able to access and view employee records. Otherwise, they should be kept well and truly secure and under lock and key. Okay, so what are some of the practical realities coming out of what we've talked about this evening in terms of record keeping? So here's the thing. Good record keeping is fundamentally your proof that employment matters are being dealt with correctly. If there is ever a dispute, having the paperwork accurately stored and readily available makes it easy to determine the truth of a situation. It isn't difficult to do. Set up your systems and follow them. It's not difficult. A little bit often will make all the difference. So at this stage this evening, there's a few questions that I want to ask you as business owners and managers. Do you know what records you must keep? Do you know what information you must give staff when you employ them? Do you know the difference between an employee and an independent contractor? Do you know that you must provide payslips and what information must be included on them? Do you know what award your staff, or awards, if you have more than one award that applies to the staff you employ, are covered by, and those entitlements? Are you paying your staff correctly? How do you know? That's next week's topic, by the way. Do you know how to end a staff member's employment lawfully? Do you know what level of HR risk you currently have in your business? Do you have employment contracts? That was last week's webinar if you want to go back and have a look at that. Do your employment contracts comply with legislation, meet Fair Work requirements and the National Employment Standards? Do you have a clear set of position descriptions to ensure that roles are clear and teams are effective? Do you find it easy to recruit and retain quality staff? Do your staff know more about their rights and responsibilities than you do? Do you have a good set of core HR policies that mitigate your workplace risks such as health and safety, bullying, harassment and discrimination? That's going to be our final in this basic series, our 4th webinar, so not next week, the week after. And could you confidently defend a claim against your business? I'm going to leave you with those questions, and we will actually pop them up in the fact sheet for this evening's webinar so that you can self-answer them and then decide if you need to reach out and talk about those elements further in terms of your business. I haven't had any questions as yet in the chat screen, but you've got our contact details there, so please reach out if you have questions relating to your business that we might be able to answer for you. In the meantime, thank you so much for joining us today. We really appreciate you being here. We are delighted to be partnering with Business New South Wales for this celebration of Small Business Month and to be able to help you with back to business basics for small business. A reminder, if you do have specific questions about your business or you want us to help you out in any way, contact us anytime. You've got our phone, email, Facebook, etc. contact information. We'd be very happy to talk with you and give you some guidance. Next week's webinar, we'll be discussing the 3rd in our Back to Basics series, celebrating Small Business Month. Are you paying your staff correctly? So join us at 5:30 p.m. next Wednesday to ensure you're getting this part right. Again, delightful to have you with us this evening. Thank you so much for joining us, and we'll look forward to seeing you next week. Thank you so much.